بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين على نبينا محمد وعلى آله وصحبه أجمعين اللهم علمنا ما ينفعنا وانفعنا بما علمتنا إنك أنت الجواد الكريم. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another and probably the final episode in our series on Al-Qawa'id Al-Fiqhiyya, Islamic legal maxims. Today's maxim is Al-Mawa'id بصور التعاليق تكون لازمة. Conditional promises are binding. This is one of those rare maxims where the translation is actually shorter than the Arabic. This maxim was initially proposed by the Hanafi school, and it reflects their position on the issue of whether or not maxim highlights further the distinction that the Hanafis make between different kinds of promises. This particular phrasing says, لا يلزم الوعد إلا إذا كان معلقا. Promises are not binding unless they're conditional. So what that means is that a simple promise is not legally binding, but if one party makes a promise to another that if such and such happens, then I will do such and such, and that thing that is the condition actually does occur, then the offerer of the promise is legally bound to keep his word. Now, the condition that triggers fulfillment of the promise could be performance of an act by the promisee, or it could be some event that happens, somebody else does it, something occurs. It could even be that the promisee refrains from doing an act within some stipulated period of time. If you look at the words that comprise the maxim, the Arabic words, mawa'id is the plural of maw'id, which is derived from the word wa'ada ya'idu, to promise. And maw'id is, its basic form in Arabic language would be a noun of time or place related to that verb. So the time in which a promise is supposed to take place, or the place in which a promise is supposed to occur. And from that, then you get maw'id is also translated as appointment, but it also means a promise, a pledge, a commitment. And ta'liq is another key word in the maxim. It's derived from the verb allaqa yu'alliqu, which means to hang something on another, to attach, to suspend. And that can be physical. You can hang your shirt on a rack, or it can be abstract, in which case it means to make one thing conditional, dependent, or contingent upon another. So that's what it means here. And then lazima is derived from the verb lazima, yalzamu, to cling, adhere, accompany. And then because if something is always with something else, then the derived meaning is that of scholars, the basic ruling on a promise to perform a lawful but non-obligatory act is that fulfilling it is highly recommended and failing to fulfill it is highly disliked. But according to the majority of scholars, failing to fulfill it falls short of being a sin. So an example of that, a person tells his friend that he's going to settle his debt for him, and then he changes his mind. So that promise is not legally binding, and he can't be forced to pay, and it's not a good thing, but it's not a sin per se, with one exception, which is if he never intended to fulfill it when at the time that he was making the promise, then that's definitely a sin. But if that's not the case, then it falls outside the parameters. Now, according to the Hanafis, though, if party A says, look, go ahead and sell this, and if you don't get paid for it, sell it to so-and-so. If he, for some reason, doesn't pay you, I'll pay you. And then the guy who bought it ends up not paying, then this promiser, who is a guarantor, then he's legally bound to fulfill his promise. Now, the Maliki position is really close to the Hanafis. They say if a promise is linked to a cause and the promisee starts doing an action based upon the promise, as soon as the promisee begins the action, then the promise becomes binding. So from the wording of the Hanafis, it doesn't become binding until that action is completed. The Malikis have actually a slightly broader application or interpretation of this principle. Now, there's one caveat to when does this maxim apply and when does it not apply. Of course, it doesn't apply if the promised act is a violation of the Sharia. So, for instance, if one partner promises his partner that I will guarantee your share in this joint enterprise, you will not suffer any loss, that promise is non-Sharia compliant because the nature of a musharaka contract is that the parties share in the risk. And so if one of the parties tells the other that there's no way that you're going to be exposed to any risk, I will bear all the risk, that's not a partnership anymore. Now, if we look at Sharia evidence for this principle, in Surah As-Saf, Allah says, بعد أعوذ بالله من الشيطان الرجيم, يا أيها الذين آمنوا لم تقولون ما لا تفعلون. O you who believe, why do you say what you do not do? Now, that's a question, but it's a rhetorical question. So the meaning there is a rebuke. And the rebuke is made explicit in the following verse. كَبُرَ مَقْتًا عِنْدَ اللَّهِ أَن تَقُولُوا مَا لَا تَفْعَلُونَ. It is most loathsome in the sight of Allah that you say what you do not do. So making a promise and then failing to fulfill it without any excuse would fall within the general meaning of this wording. In addition, the Quran is full of statements that Allah doesn't break His promise, that Allah fulfills His promises. An example of that, بعد أعوذ بالله من الشيطان الرجيم, لكن الذين اتقوا streams. This is a promise from Allah. Allah does not break His promise. Now, on top of that, the Quran identifies the breaking of a promise as a cause of hypocrisy. In Surah At-Tawbah, فَأَعْقَبَهُمْ نِفَاقًا فِي قُلُوبِهِمْ إِلَى يَوْمِ يَلْقَوْنَهُ بِمَا أَخْلَفُوا اللَّهَ مَا وَعَدُوهُ وَبِمَا كَانُوا يَكْذِبُونَ. So as a consequence, He put hypocrisy into their hearts to remain therein until the day they meet Him, because they broke their promise to Allah and because they used to lie. Okay, now this verse is extremely relevant to the Hanafi position because the promise that's referred to in that verse was conditional. The previous verse states, وَمِنْهُمْ من عاهد الله لئن آتانا من فضله لنصدقن ولنكونن من الصالحين فلما آتاهم من فضله بخلوا به وتولوا وهم معرضون. There are some among them who make a pledge to Allah, saying, if Allah gives us some of His bounty, we will surely spend in charity and be righteous. But when He did give them some of His bounty, they were stingy with it and turned obstinately away. So the fact that they made a promise, oh Allah, if you do this for me, I'll do this. And then He fulfilled what they were asking for, and then they didn't fulfill their pledge. This had devastating effects on their faith. Take a break here and be back in a minute, inshallah.
Assalamu alaikum. I am Ja'far Idris. You are watching Peace TV, the solution for humanity.
Assalamu alaikum wa rahmatullah. Welcome back. So we're discussing the evidence for this maxim that conditional promises are binding. And we're talking about the Quranic linkage between breaking a conditional promise and its effect of producing hypocrisy in the heart of the violator, the breaker of the promise. There's a well-known hadith that also makes that linkage. The Prophet ﷺ, hadith reported by Bukhari and Muslim, Ayatul munafiqi thalathun, idha haddatha kadhab, wa idha wa'ada akhlafa, wa idha tumina khan. The signs of a hypocrite are three. When he speaks, he lies. When he promises, he breaks his promise. And when he is entrusted, he betrays the trust. So, scholars qualify, or they explain what this wording means. One explanation, that these are signs of hypocrisy when they become a regular part of a person's behavior. And with regard to breaking a promise in particular, it's an attribute of a hypocrite when the promiser has no intention of ever fulfilling the promise he makes, as we mentioned earlier. So, scholars agree that it's haram to make a promise that one has no intention of fulfilling. The Hanafis, they say that the wording of a simple promise is not strong enough to make an optional act binding. And they call attention to an issue of fiqh that everybody agrees upon. One person promises to give a gift to another person, and then the promiser goes bankrupt. Now, he's got various debt obligations. That's why he's bankrupt. And his creditors have lined up. When this happens, the case goes before a court. The person's having trouble meeting his obligations. His creditors complain. He's brought to court. And if the judge determines that he really doesn't have the ability to pay back the obligations that are upon him, then he's declared bankrupt. And when that happens, then everybody to whom he owes money becomes this pool of creditors that have a right to whatever revenue can be gained from the sale of his property that's not essential for his living. So as this stuff is sold off, then the creditors are given the proceeds in proportion to their share of his total debt. All the scholars agree that the receiver of the promise to get a gift, he's not part of that pool of individuals who have a right to the proceeds from the sale of the bankrupt's assets. Would make it legally binding when the act is optional. But the wording of a conditional promise increases the linkage between the promise and this trigger event, and when it occurs, then the fact that this promise has been linked in this way makes the resolve of the promisor much stronger and thus legally binding. If we also look for other evidence for why this principle should be valid, the Prophet ﷺ, he said, "La darara wa la dirar." This famous statement which became in itself a legal maxim, which we discussed when we were talking about ad-darar yuzal, which is another phrasing of the same principle. Harm should neither be initiated nor reciprocated. And a breach of promise is almost inevitably going to cause harm to the promisee, and particularly if the promisee has undertaken actions and incurred expenses as a result of the promise. And so Az-Zarqa, he said, Ahmad Az-Zarqa, who did a commentary on the Majalla, he said that people are in general need of a provision that treats promises as binding when they're predicated on fulfillment of a condition, and the condition has been fulfilled. To treat them otherwise would promote financial harm in society. So, applications of this maxim in fiqh: Party A sells a property to Party B for a price slightly higher than the market price. Party B regrets the sale and comes back to A. A says, "Look, if you can find me somebody else who's willing to buy it, I'll release you from the original sale." And so Party B looks around and he finds someone who's willing to buy it, and so he guides him to this Party A, and the sale is revoked, the original one. The example that we mentioned earlier of kafala, a third party comes in between a buyer and a seller, and he says to the seller, if the buyer doesn't pay for some reason, I'll pay. These are like a deferred payment sale. If the buyer for some reason doesn't pay, then the guarantor is obliged. Now, this particular manifestation, I'm not aware of any difference of opinion among any. It was a principle that was affirmed by the Islamic Fiqh Academy of the OIC, is a promise to purchase in a murabaha sale. In the way that murabaha works in modern times, a customer approaches the bank and says, I want to import this machine and it costs $500,000, I don't have the money. And the bank says, okay, we'll buy that machine and sell it to you, but you have to promise that you're going to buy it, because that's a lot of money. We buy it and then you decide you don't want it from us, that puts us in a difficult position. So Islamic Fiqh Academy said that in that situation, what banks do is that they sign an initial agreement with the customer, and the customer, what that agreement is a promise from the customer that if the bank offers to sell him a good that matches all of these specifications, that he promises to buy it. Now, the reason that's needed is that the bank cannot enter into a contract to sell that good if it doesn't own it at the time of the contract. The Prophet ﷺ said, "La tabi' ma laysa 'indak." Don't sell what you don't possess. So, for the bank to say, okay, we'll sell you that machine, when it doesn't yet own it, it can't do that. So, in order for the bank to protect itself, it has to first enter into an agreement with the customer, in which the customer promises to buy. If the bank does what the bank walks away from that sale and doesn't purchase it, then the bank has the right to recover actual losses. So let's say, it had paid $500,000 for it, and it had originally promise to sell it to the customer for $600,000, and then it finds somebody who's willing to pay $400,000 for it. What it can claim recompense for is its actual damages. So it put out $500,000 and it lost $100,000. So that's what the promisor is obliged to repay it. This is an example from takaful. Those who have subscribed to a takaful fund, if they promise to share any surplus from the underwriting fund with a takaful operator at the end of the year, they're obliged to honor that promise in case a surplus is realized. This is a very controversial point I'm about to mention here. Is Islamic banks face a problem with certain customers who are unscrupulous. If they borrow from a conventional bank and they don't pay their stuff on time, the bank will penalize them in a financial manner. So the amount that they owe the bank increases because they missed a payment. Now, Islamic banks are, by the nature of their business, they're not allowed to do that, because that's riba. So what happened in the actual practice of Islamic banking is that there were people who would take one loan from an Islamic bank, one loan from a conventional bank, and they were very punctual about paying their obligations to the conventional bank because there would be a penalty involved if they didn't. When it came to the Islamic bank, it was, khalli wali, I'll pay it when I get around to it. No, you can't do that. The Prophet ﷺ, he said, matalul ghani dhulmun. Procrastination in payment on the part of a person who's rich is oppression. And in another version of that same principle, he said that this act, that it yuhillu irdahu wa uqubatahu, it makes it lawful to damage this person. This man doesn't fulfill his obligations. That's, damaging his honor. And it also makes it lawful to punish him. In classical fiqh, they said the punishment there is imprisonment until he pays. There are some scholars in the modern era who said that a person in this situation, the bank can ask the customer to sign a promise that if they delay payment when they are able to pay, that they promise to pay a certain amount that will be channeled to charity, not to the bank. And some scholars have allowed it, some have not. It's a controversial point. We've run out of time. Assalamu alaikum wa rahmatullahi wa barakatuh. Wallahu a'lam.